Welcome to Greene Light for Justice, saving the world one case at a time.
Hello and welcome to Greene Light for Justice, saving the world one case at a time with experienced attorney Michael S. Greene. For over 30 years, Michael has aggressively represented and won cases for his clients who need an experienced lawyer for all types of accidents, personal injury, medical and nursing home malpractice, wrongful death, and premise liability claims. I am your host, Kevin Rosenquist, and today's episode is From Collision to Compensation, Understanding Auto Accident Legal Battles in Maryland. Michael, welcome.
Good morning. How are you, Kevin?
I'm doing great. Excited to chat with you. Thanks for being here. So
thank you.
Let's start here. What are the most common types of serious injuries you see in auto accident cases out there in Maryland?
Oh my goodness. It's incredible. I mean, starting from worst, death. We see death cases, paralysis, amputations, traumatic brain injury, TBI, it's known as, neck and back, disc herniations, broken bones, damage to internal organs. It could be your heart, your spleen. With women who are pregnant, I mean, they could lose a pregnancy, they could lose the baby. It really gives you a feel for how dangerous things are out there and how important it is to be safe.
Yeah, no doubt. No doubt. So can you sort of explain the legal process for individuals who have suffered a serious injury in an auto accident in Maryland? Like how do the stages of a case sort of unfold?
Each case is different. Every incident in life is different, but there are common threads and common procedures that are for many of the motor vehicle accidents, motor vehicle crashes. We actually they're called motor vehicle accidents because they were generally not done intentionally by the wrongdoer,
sure.
But we call them crashes. Because they're not just accidents. An accident is something that just happens. It's not foreseeable. And that's a legal term, believe it or not. Something that's foreseeable, for example, is if you have somebody who's driving drunk, somebody who's driving drugged, somebody who's distracted using a cell phone. It is foreseeable that something bad is going to happen, is likely to happen. So first we have the crash. The second thing I would say is take care of the injured person. That you don't need to be a lawyer to know to do. You actually have to not think about the situation as a legal claim at that point. We want to take care of the injured person. We want to make sure that they get medical treatment. Health is the most important thing, and it doesn't take a lawyer to tell you that. Your health and your life, most important thing, so that's what we do. That's the second thing after the crash. The third thing is the attorney will gather evidence to support the injured person's claim. So basically, we're looking to put together the pieces of the puzzle, gather the pieces of the puzzle, preserve the evidence. What would evidence include in a case? It could be witness identification, talking to witnesses, getting witness statements, obtaining our clients' medical records and bills, getting proof, gathering proof of the harms and losses that the injured client has sustained and may continue to suffer. So we want to gather the proof of the harms and losses like pain and suffering, loss of income, loss of ability to work. What else are we doing in this third step of gathering evidence? We may need to hire expert witnesses to prove a case. We may need to hire crash reconstructionists. We may need to hire medical experts to help prove cases. There are a lot of complex rules. Once again, the clients do not need to worry about this. This is why you have somebody that you can trust that can take care of these things. So we're gathering all that evidence, whatever that may be. If there are going to be financial losses to the family, if somebody died as a result of a crash or any other type of negligence, the family is going to have financial losses usually if it's a breadwinner. The fourth thing we do after we gather all this evidence, we sit down, we review it. I review it with my clients. We draft a very detailed demand package for settlement, a demand for settlement to the at-fault person's insurance company. And we attempt to settle the case, to resolve the case for an amount that is fair, that fairly compensates the injured person and their family if it's a death case, the lawyer will attempt to negotiate with the insurance company for the at-fault person. Some cases settle at that stage. It all depends. There are a lot of moving parts. It depends how much insurance there is, if there's enough insurance, if there's any dispute over fault or dispute over the extent of the harms and losses. The harms and losses we call damages. In any event, the fifth step is if the insurance company does not make a fair offer, then I get out of my hoodie and I put on my suit, jacket, and tie, and we get down to business and we file a civil lawsuit against the wrongdoer and we litigate the case. Litigation is a word that's your court process. That's going through everything from filing the lawsuit to exchanging information with the other side. And once again, a lot of complex laws and rules that's why it's important to have a highly experienced attorney that you can trust taking care of that. So you don't have to worry about any of that. But the litigation process can be taxing. It can be stressful, but what we do, what your attorney will do is do all that work for you, take that burden off of you, lighten the burden for you. You have the injured person has things to worry about, like their health, their life, their safety, and their family. So the attorney will take care of that legal process for you. So the litigation process, ultimately, either the case is it could settle during the litigation process, or the case could go to the jury. And if the insurance company is not going to make a fair offer, you put them in a corner and you cut off all their means of escape. And eventually they may realize that they need to make a fair offer. And if they don't, we let the jury decide. And that's how that works.
You mentioned foreseeable before. I'm curious. You've been doing this a long time. Obviously, drunk driving is nothing new. That's been around forever. But with the texting, how have you seen that change the auto accidents? The frequency of auto accidents and things in your practice. Do you see a large increase because of it?
Yes. It's mind-boggling. And when you're driving on the highway, just look around, look at the people around you. You see the car coming up on your rear, and you look around, you see a car that's swerving, and you look over and the person's texting or
It's frustrating.
It's either we see a lot. I'm going to call it like it is. I'm going to tell it like it is. There are a lot more idiots and a lot more assholes on the road. Okay. So be careful. Look out for those. Look out for the idiots. Look out for the assholes. Protect yourself. Be safe. But yeah, we see a lot of distracted driving. There's still, believe it or not, impaired drivers. You see people, if you're driving with the marijuana laws, you see being relaxed. Sure, people smoke marijuana, but regardless of what the laws are, you can't be smoking it while you're driving. And around here, you're driving on the road, you smell it, it's everywhere. It sometimes can be a challenge to prove, even in a criminal case, when the state's trying to prove a case that somebody was impaired by a drug other than alcohol. With alcohol, a blood alcohol test can be given, and an impairment or intoxication can be proved. But with other drugs, there aren't such simple tests. It requires the drug recognition expert. So we tie our civil cases in. If there happens to be a criminal case too, we can use the criminal case to gather evidence.
Okay. Yeah. Can you talk about Maryland's contributory negligence rule impact on auto accident cases involving serious injury?
Sure. You would think Maryland, being a blue state and as liberal as the legislature and the government is here, that there would be more protection for people who are injured as a result of the fault of others. But contributory negligence this is an old unfair law that exists in Maryland. Maryland is one of only 4 states in the country that have this law called contributory negligence, or contrib. So with contributory negligence, even if the injured person is just a tiny bit at fault, 1%, just slightly at fault, then under this law of contributory negligence, there may be no recovery. And this is a very harsh result. The other 48 states or so do not have this concept, this law of contributory negligence. They have what's called comparative negligence, comparative fault, where even if you're a little bit at fault, you can still make a recovery. You just compare the amount of fault between the really at fault driver and the injured person who may have made a slight mistake. There are a few exceptions to overcome this harsh law of contributory negligence. And once again, it's just complex laws that your trusted lawyer will consider and hopefully be able to overcome. I'm going to just say the name of one of these exceptions. It's called the doctrine of last clear chance, which basically says that even if the injured person is contributory negligent, that if the truly at fault person had the last clear chance to avoid the crash, then you can still hold them responsible for their negligence.
Okay.
But this has to be handled correctly. Once again, it's another reason why get somebody that you trust on your side to take care of this so you don't have to worry about it. And remember not to be speaking to the other person, the adverse party's insurance company or any of their representatives, because whatever you say could be turned around and used against you.
Right. You
think you're doing the right thing, and then they turn around and they shove it down your throat, and it's not pretty. So those are important things to remember.
Absolutely. What are the key factors that determine how much compensation a person can receive after a serious auto accident injury?
Usually it's about the damages. And that's that legal term that I may have mentioned a little bit before. That's damages are your harms and your losses that the injured person and or their family have suffered and may continue to suffer. Compensatory damages are damages meant to compensate, to make up for your losses. There are two main categories of compensatory damages. There are economic damages on one hand, and there are non-economic damages on the other hand. Economic damages, for example, could be medical bills, past, present, and future, loss of income, past, present, and future. Some people who are injured, then if they can't work for the rest of their lives, we may want to, I oftentimes will hire expert witnesses for vocational experts, economist experts to prove this loss of future earnings. And in death cases, if a parent were killed, the children would be without financial support or the reduced financial support. So we have to consider that. So all of those things. And another big one is when there's a permanent injury, such as brain damage, traumatic brain injury, or something where somebody needs care, medical care, life care for the rest of their lives. We often will hire what's called a life care planner. And that's an experienced medical professional who goes through and determines what the future life care plans are. For example, similar to if there is a birth injury where a child was injured at birth, a baby was injured at birth, and they need a life care for the rest of their lives. We need to factor in all of that, home health aides and modifications of a house and nursing care and medical care. We factor all of that in because when you settle a case or if it's resolved at trial, either way, you get one shot. So we have to know. That's why the attorney puts all of that information together, all of that evidence together in order to prove what damages, what amount of money do you need now to compensate you to make up for all of those losses that haven't even occurred yet, that they will be occurring for the rest of one's life. So those are compensatory damages. And the economic types. The non-economic, very important. It's pain, suffering, past, present, and future. In death cases, it's called loss of solatium, which is basically your loss, your loss of your loved one. You're not having them around anymore. So that's a big element of damages as well. And there is another type of damages. It's called punitive damages. Those, once again, in Maryland, you would think that with such a liberal state that you'd be able to get punitive damages. And punitive damages are meant to punish somebody for intentional wrongdoing. But the only way really to get those types of damages awarded in Maryland is if you can show an actual intent to injure, actual malice, ill will, and intent to injure. It's possible, but they're generally not going to happen in motor vehicle crash cases. Motor vehicle crash cases are negligence cases. They're not intentional cases. They may be foreseeable, but they're not intentional. And you asked, the question was about damages. How much compensation can a person receive? So all of those things go into calculating damages. But then a big question is how much insurance and or assets are available to collect to pay those. You can have somebody who's got a $5 million value of their damages with pain and suffering and medical bills and future life care plan and loss of income. Hopefully there's enough insurance or assets, whether it's from a motor vehicle insurance company or the trucking insurance company, or if the injured person themselves has enough uninsured or underinsured motorist coverage to pay for these damages.
What should someone do immediately after being involved in an auto accident to ensure that their rights are protected, especially if they've sustained any serious injuries?
Sure. The first thing, and I briefly mentioned this before, is take care of yourself first. Don't think that, oh, this is a motor vehicle crash and I have to do this, that, or the other. If you're injured, you don't need to be thinking about those things.
Right.
You're either in an ambulance or, God forbid, if you were killed and your relative is dealing with their grief, don't fill your head with those types of with legal issues. Think about it as if you were injured in any situation, you're not just get to the hospital, get your medical treatment, get yourself better. The second thing you do with respect to any legal issues is you don't communicate with anybody other than your doctors, possibly. Don't communicate with anybody about the case other than a lawyer. Let the lawyer take care of that. And that's just as simple as it is.
All right. Well, thanks for tuning in to Greene Light for Justice, saving the world one case at a time. To connect with Michael and the team, you can call 800-238-4960. And please like and subscribe to our channel and leave us a review if you can. Michael, great having you here. Looking forward to talking with you in the future.
Yeah, thank you very much, Kevin. Appreciate it.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.